Let's go. Oop, you little bastard. There. That looks about right. Let's do that. Fordham Law Review, Volume 15, Issue 2, Article 3, 1946. Enemy Business Enterprises and the Alien Property Custodian. 1. Francis X. Fallon Jr. And let's see if I can make this bigger and still keep it on the screen. I think we can. Oh, yeah. Kind of get you centered over here. All right. So we've been studying the Trading with the Enemy Act. This got brought about by another gentleman who had been studying the military manuals and the War Powers Act and Title 50 and a couple war manuals that were brought to his attention. They're part of the Department of Defense. There's also a military manual on peace as well. But his primary focus was on the Trading with the Enemy Act, Alien Property Custodian, and War Powers Act. And so he turned me on to it and said, I'd like to get your collective perspective on it. And I said, well, I have to read into it a little bit more. I'm familiar with the Trading with the Enemy Act because of the 73rd Congress. Volume 77, Part 1, goes into the amending of the October 6th, 1917 original Trading with the Enemy Act. And so I'm familiar with it. And he goes, I think you should go a little bit deeper into it. And so I said, okay. He ran me through what knowledge he had acquired of the Alien Property Custodian and the Trading with the Enemy Act and the amendments. And of course, you know how I like to do it. If I'm going to be into it, I'm going to be balls deep. I'm either all in or I'm all out. There's no in between. So for the last few weeks, I have been ripping apart the Trading with the Enemy Act. And there is a lot of beneficial interest for you and your family within. And today we're going to cover some hard-hitting facts that maybe you weren't made aware of. I'll be honest with you, most people in college aren't getting this kind of education. They're paying out the wazoo. They'll be in debt for the rest of their life, but they're never going to acquire this kind of knowledge or literature or be led in this direction because it's not advantageous to the system to teach people how to handle their own affairs. So with that said, take everything here with a grain of salt, do your own research, but there is remedy in what I'm sharing with you. And over the last, couple months, I've been sharing some very, very valuable information. I'm not going to tell you how to execute it. All I can do is present the information to you, and it's up to you to perfect your execution of it. But the answer herein lies within these documents that I'm sharing with you and reading to you. In part, some of the reason that I'm reading them is that I have a near and dear friend who's losing his vision, and it pains him to try to read any longer. And so I make these videos also for his benefit, but they benefit everybody. So, Enemy Business Enterprises and the Alien Property Custodian, 1, Francis X. Fallon Jr., Introduction. Approximately 3 months after Pearl Harbor, the president established the Office of Alien Property Custodian to deal with certain specific and limited kinds of foreign property and property interest in the United States. Included were only those types for which the already existing blocking and freezing controls of the Treasury Department were considered inadequate to protect the national interest after the outbreak of war. The executive order delegated to the custodian discretionary jurisdiction over four principal types of such property and interest: enemy business enterprises, enemy physical property, real and personal, patents, enemy and foreign, and enemy property under judicial administration. Now, the importance of this is the fact that the United States has always been at war. All right. When the District of Columbia was established with the succession of Maryland and Virginia, it had been long in the works of creating a military world power and world force policing power, and that was going to be the District of Columbia. So you've got three sovereign city states and nations. You've got the Washington, D.C. District of Columbia, known as the United States, 10 square mile area. You have the Roman Vatican, and then you have the City of London. So the trilogy of sovereign city-states and nations, all right? And the Vatican is the spiritual aspect of it. The City of London, Lloyds of London, the banking aspects of it. And then you've got the policing enforcement power, Washington, D.C., all right? And so being that the United States is always at war, whether it's at war with poverty, at war with drugs, at war with, the national emergencies, war with other countries, whatever it may be, you'll notice that the United States is always at war, always. And I found it very interesting. I found a piece one time that showed all the wars that Iran had been involved in, and there were only like 2 or 3 of them ever that were recorded that Iran had actually been involved in. And because at one point the United States was looking to go take over Iran as well when they did Libya and Iraq and all these other Middle East countries. Iran was on the hit list, and so the document that I had read showed Iran only being in 3 or 4, maybe 5 controversies throughout notable history. And then the United States had literally been in almost 70 or 80 conflicts, ranging from being over in Somalia to the Middle East to Cuba. I mean, it was just an ungodly amount. And you look at all these other nations, and they're allies of the United States. However, they weren't directly involved in any of the conflicts that the United States was involved in, to prove my point. So with that said, keep in mind that the Trading with the Enemy Act of 1917 is for when in time of war, and then as it was amended in 33 under the 73rd Congress, also is in play during time of national emergency, which there's a national emergency on agriculture, has been since 1933. There's been a national emergency on banking since 1933, with the banking holiday still in place and all the proclamations still in place. So we'll move forward with that comprehension and understanding, and maybe this will help point you in the direction that you need to be looking at. Discretionary jurisdiction over 4 principal types of such property and interest: enemy business enterprises, enemy physical property, real and personal, patents, enemy and foreign, and enemy property under judicial administration. The Treasury remained in control in all cases where the custodian was not given jurisdiction or did not exercise it. The custodian, although thus limited as to property, received far broader and more effective powers than those possessed by the custodian in World War I. The Treasury Department's previous peacetime powers were likewise substantially increased. Both extensions of power were the result of the amendment to Section 5B of Trading with the Enemy Act, made by Title III of the First War Powers Act of 1941, effective December 18th, 1941. By far the largest and most important part of the total property and an interest vested or controlled by the custodian consists of business enterprises and interest therein. The net equity of the custodian's vested ownership interest in enemy business enterprises is roughly 150 million, or approximately three-fourths of the total value of all property vested. The 408 business enterprises, or 408 business enterprises in which the custodian has vested enemy ownership interest, have totaled assets of over 375 million and are of almost every conceivable type and form. They include individual proprietorships, partnerships, business trusts, and associations, nonprofit organizations, domestic and foreign corporations, and domestic branches or agencies of foreign organizations of various kinds, and engage in a wide variety of business activity. The interests vested were almost entirely from German, Japanese, and Italian former owners, and the custodian's proportionate equity in the respective enterprise runs from an average minimum minority interest of 25% to complete ownership. Many of the enterprises, particularly those of former German nationality, contributed directly and substantially to the war effort. It is obvious that the activities of the custodian in this field amount to government in business on a vast and hitherto unprecedented scale, unapproached in World War I, and wholly inconceivable under any circumstances other than those created by the impact of total war. Basic problems of economic, political, and social policy in the relationship between public and private rights, government and businesses, national interest, and individual gain have arisen for re-examination, bringing related legal questions for study and decision. The experience of World War I has been of immeasurable value both to the government and to the public in considering these problems, but has been somewhat less helpful to the bar, both in and out of government, in seeking answers to the numerous and sometimes novel and difficult legal problems which have followed upon the establishment and operation of the custodian's office. Our business economy, particularly in its international aspect, became considerably more complex in the years intervening between the two wars, and devices for foreign ownership and control of property and interest in this country more numerous and varied. Foreign interests were astute in devising new methods for cloaking or concealing beneficial ownership or control. In anticipation of a renewal of conflict, the complete scheme for control of enemy property envisaged by the Trading with the Enemy Act of 1917 rapidly became obsolete and inadequate. And even in advance of our actual involvement in the war, it became necessary to establish a wholly new and flexible system for coping with the modern means of economic warfare employed by the Axis powers. The new system instituted by the Treasury blocking and freezing controls operated almost entirely by administrative rather than legislative action. It was only natural that this pre-war experience was largely drawn on in fashioning instruments for dealing with enemy property after war was begun. Administrative actions under broad legislative and executive delegations of power was adopted, and the more specific legislative provisions of World War I largely disregarded. The first War Powers Act, although in form and amendment to the earlier statute, in fact, was the beginning of a quite different and elastic method for dealing with enemy property. The bill was drafted several months before the custodian's office came into existence, and there is indication that it was considered by its framers merely as a logical extension of the pre war powers of the Treasury, to be exercised in the same manner and by the same agency. Moreover, the act was considered by some, and perhaps designed as a virtually autonomous and complete legislative enactment independent of World War I statute and self sustaining. New concepts of power, new powers, and a new status were given to the custodian. New terms and definitions were used in describing persons and property subject to the statute. But the Trading with the Enemy Act of 1917 remained on the books and was even given new life by the declaration of war. Immediately, however, some provisions of the old statute became in terms inapplicable. Other provisions appeared inconsistent, contradictory, and difficult, if not impossible, of application in the light of the amendment. The applicability of still other provisions became matters for the courts to decide. Finally, the experiment in wartime dual control of foreign property and interest, as established by the division of jurisdiction between the Treasury and the custodian, was virtually without precedent in World War I. Administrative delegations by the president of wartime regulatory powers under both old and new statutes to the Treasury and the custodian, and of wartime vesting or seizure powers under the new statute only to the custodian, created additional difficulties. The custodian's office also became an instrument of dual control, in that it was given vast governmental regulatory powers as well as the ordinary and well reorganized rights and powers of private ownership under domestic law. These two quite different bases of authority were at the same time differences in status and function. In some cases, they supplemented, in others duplicated or overlapped each other. In still others, possibilities of conflict of activity and even of interest arose. There was also the question whether the custodian's vesting powers in World War II were the same or different, greater or less than his demand and seizure powers in World War I, and to what extent the array of judicial decisions dealing with the incidents of the latter were applicable to the former. All of these circumstances have resulted in the emergence of a number of legal problems which are only now being subjected to judicial and legislative scrutiny. As was the case after the last war, it may reasonably be expected that many years will elapse before all have been solved one way or the other. Some may only be resolved some may only be solved by international action through treaty or convention or at peace conferences. Some others, happily, are presently on their way to judicial or legislative solutions. Only a few have actually been solved. Meantime, the custodian's office has been functioning steadily and its works progressing, at least in the business enterprise field. The initial phase of vesting or seizure of enemy property and interest seems to have been largely completed, but for a few odds and ends. The process of administration or liquidation is in advanced stages, and the program for sale or other dispositions of vested property and interest well begun. More recent developments indicate that the final phases adjudicated of claims and suits and return of property and interest vested are already on the threshold. It may therefore be an appropriate point at which to attempt an appraisal of some of the legal problems with which the custodian has dealt and continues to deal in the most significant of his field of activity, that of enemy business enterprises. An effort will be made to discuss the problem in the order of the various phases of activity to which they relate. vesting administration, etc. A necessary preliminary to any such discussion, however, is an examination in some detail of the basis of the custodian's jurisdiction and powers, the statute, and the executive order. By amending Section 5B of the statute, Congress gave the president or his delegate sweeping regulatory powers over any and all property in which any foreign interest existed. And in addition, the vesting power, the jurisdictional basis of the power conferred, is both in personam and in rem. Should be carefully noted, however, that although broad regulatory powers exist over any property in which any foreign country or a national thereof has any interest, the vesting power extends only to the property or interest of such foreign country or national. This is indication enough that Congress did not intend American property interests to be expatriated by our government. This is the source of the vesting and regulatory powers delegated to the custodian. He must exercise them, however, only with respect to the property and interest of designated enemy countries or nationals thereof. Such nationals are, of course, but a limited class of the foreign nationals, referred to but nowhere defined in the statute. Impliedly, the power of definition was likewise delegated, and recourse must be had to Executive Order 8389 as amended for its various meanings. National is there defined to include 1. Any person domiciled in or a subject, citizen, or resident of a foreign country. 2. Any partnership, association, corporation, or other organization organized under the laws of, having its principal place of business in, being controlled by, or a substantial part of the ownership interest in which are owned or controlled directly or indirectly by a foreign country or national thereof. 3. Any person to the extent acting or purporting to act directly or indirectly for the benefit or on behalf of any foreign national. And 4. Any other person who there is reasonable cause to believe is a foreign national. The most sweeping provisions are, of course, the latter two. The retroactive effect of all the definitions is, however, frequently overlooked. A foreign national is any person who fell within the requirements of the definition at any time on or since the effective date of Executive Order 8389 as amended, which is no later than June 14, 1941, subsequent change of residence or status or cessation of active hostilities make no difference. These definitions control the custodian's determination of who are enemy nationals with certain limited exceptions. A person not within an enemy country shall not be deemed an enemy national unless the custodian determines 1. That such person is controlled by, acting for, or on behalf of, including cloaks for, a person within an enemy country. 2. That such person is within an enemy-occupied country and is also a citizen or subject of an enemy country. Or 3. That the national interest requires such person to be treated as an enemy national. The most significant feature of the new definitions are their retroactivity and flexibility. Citizenship, residence, place of organization, and place of doing business are no longer the sole criteria. Indica of agency and control have been added, as well as the reasonable cause to believe and national interest test, giving a vast field for the exercise of administrative discretion in the making of finding and determination. Exercise of the custodian's powers vesting. A. Finding and determination. The custodian exercises his power of vesting or supervision of business enterprises or interests therein by the execution of specific orders designated by number, identified by the name of the enterprise or former owner of the property or interest vested, published in the Federal Register, and served on the proper parties. Since his jurisdiction is limited by the executive order, his order contains certain findings and determinations to bring his exercise of jurisdiction within its provision. Commonly accepted administrative law doctrines require findings of facts to be specific, not merely a repetition or rephrasing of the statute or executive order delegating the power to the administrative agency. In the light of this requirement, the different differentiation between findings and determinations made in the custodian's vesting and supervisory orders is somewhat curious. The findings employed by the custodian are generally of two kinds. One, residence of the person whose property or interest is to be vested or supervised, and two, ownership of the property or interest involved. When nationality is based on residence in an enemy country, the finding is usually a specific reference to the city or other locality within the country where the national resides. If the finding of enemy nationality is based not on residence in an enemy country, but on agency, control, or cloaking, the address of the principal party or beneficial or true owner within the enemy country is usually identified in the same manner. Residence of an enemy citizen or subject within an enemy occupied country is likewise so identified. However, the custodian's jurisdiction is based quite as much upon determination of nationality as upon findings of residence, and these he invariably couches merely in the general language of the executive order, whether they be determinations of agency, control, or cloaking, or that the national interest requires the person to be treated as an enemy national. It is recognized that, especially in wartime, which we're always in war, it's always wartime, the same national interest might well forbid disclosure of the facts upon which such determinations are made. Nevertheless, a person seeking to attack such determinations is at a disadvantage when the question of enemy nationality is not merely one of residence. Agency control or cloaking determinations have been attacked. However, under sections A of the Trading with the Enemy Act, these attacks have been permitted by the courts despite the studied attempt of the executive order to make determinations or actions by the custodian thereunder conclusive. So far as is known, however, no attack has yet been directed solely against a national interest, determination of enemy nationality, nor have such determinations, although always made, ever been used to sustain a vesting where other findings or determinations in the order, enemy citizenship, residence, agency, control, or cloaking were held erroneous. Apparently, the only group of cases where the custodian vesting are grounded on national interest determination alone are those involving internees where the fact that the internee was an enemy citizen or subject would not be enough to bring him within the executive order. In view of residence in this country rather than in an enemy or enemy occupied country. Finding of ownership may vary in significant respects. The order may recite that the named enemy national owns and the custodian vests or supervises certain property specifically described in the body of the order or in an exhibit attached. or merely that all property owned by the enemy national is vested or supervised by the custodian, or that any and all rights, titles, and interest of a named enemy national in and to certain property specifically or generally described is vested or supervised by the custodian. In the latter two cases, the custodian has actually made no finding of ownership at all, or, if he has, it is in the merest general terms, and the nature of the ownership interest, or quantum of ownership in specific property has nowhere been found. The custodian has merely vested the property, rights, or interests of the enemy national, whatever they may be. This distinction first arose in World War I and is of importance in measuring the custodian's right to possession of and interest in the property the courts have held. In the first case above mentioned, that the custodian's findings are conclusive to the extent that he is entitled to immediate possession of the property. In the latter two, the issue of ownership may be raised for determination by the court before turnover of the property to the custodian. In such cases, if property is turned over to the custodian in the absence of such a finding, either by the custodian or by the court, the protection of the exculpatory provisions of the statute may not be available. The basic distinction between asset and interest vesting is also important in determining the effect of the vesting order on the property involved. In the former case, the asset itself is vested and becomes government property, with many, if not all, of the incidents thereof. In the latter case, the custodian is vested only with an interest therein, which may or may not be defined or described, and the property retains its private character. These considerations have varying consequences when applied to business enterprises. B. A domestic corporation. In the case of corporations organized under the law of one of the several states, some or all of the capital stock or shares of which are owned by enemy nationals, the custodian normally vests only such stock or shares, thus succeeding to the rights of the enemy national as stockholder. But if the degree of enemy ownership is sufficiently substantial, it may result in finding or determination by the custodian that the corporation itself is an enemy national within the meaning of the executive order. May such a finding be attacked. Only a strong factual showing that prior to the vesting the corporation was not controlled by, acting for, or on behalf of, or a cloak for an enemy national would seem to have any hope of success. The difficulties of overcoming a determination of enemy nationality made on the ground of national interest are obvious enough. Without such facts, the attack must of necessity be directed to the definition in the executive order, rather than to the action of the custodian. Moreover, the additional finding may be necessary to bring the business enterprise as a whole within the ambit of the custodian's regulatory or supervisory powers. Since there is no taking beyond the enemy national stock interest, the attack would resolve itself into one on the power to regulate or supervise, a constitutional question, or on a charge that the regulation or supervision exercised was arbitrary, unreasonable, or discriminatory in some respect, and damage would have to be shown. A different question would arise, however, if the custodian made use of his own finding by a species of administrative bootstrap lifting to vest assets owned by the corporation itself. Even if the corporation's stock is 100% enemy owned, the question may not be academic insofar as the rights of creditors are concerned, for the creditors of the corporation and those of the individual stockholders may not be the same. Where outstanding non-enemy stock interest exists, such a vesting would seem palpably improper, probably giving to the injured parties rights against the custodian under Section 9A of the Trading with the Enemy Act, only overriding considerations of national interest should cause the custodian to disregard the corporate entity in either case. It may be that a determination by the custodian of enemy ownership of corporate stocks disregarded non-enemy property interest in the stock itself. The interests of the secured creditor in enemy property were accorded some measures of protection under sections 8A of the old statute. The section appears to be applicable to vesting in World War II, despite the amendment to section 5B, surrender or loss of possession even to custodian might well deprive a pledger of his security rights. In other cases, non-enemy interest in property vested might not come within the limits of Section 8A, yet should not be without protection. Enemy-owned corporate stock might be on deposit with a non-enemy agent or fiduciary who may have acquired property rights of value in the stock by virtue of the instrument creating the relationship. The exploratory provision of the statute would protect the agent or fiduciary from liability for breach of his obligation in ascending to the demands of the custodian. But the problem of his own rights remains. For example, the stock might constitute the corpus of a trust, as to which the trustees are given voting powers for the purpose of providing continuity to the management of the corporation, in addition to their normal rights to administer the trust and receive compensation therefor. The enemy interest might be those of contingent remaindermen dependent for realization upon events, such as the predecease of life beneficiaries, which have not yet occurred. A direct vesting of all or part of the stock by the custodian in such a case would appear not only to destroy the trust, but the rights of the trustees and the non-enemy beneficiaries as well. Where the trust is a relatively passive or inactive one, or all the beneficial interests are enemy owned, its destruction by vesting action of the custodian would seem less open to question. In cases of voting trust, the custodian quite properly vests the enemy-owned voting trust certificates or the enemy-owned beneficial interest therein, as well as the underlying stock. Or he may disregard the trust agreement as a contract with an enemy suspended or dissolved by war. Even if still effective, the trust and the action of the trustees are proper subjects of the custodian's supervision. Where vested corporate stock is subject to bona fide prior restrictions on its sale in the form of first purchase or first refusal or option rights embodied in the charter or bylaws printed on the stock certificate or by contract between the parties, it would seem that the custodian's vesting would be subject to such rights, at least to the extent that they are held by non-enemies. In cases where corporate stock is subject to prior attachment, it would likewise seem that the custodian's vesting is subject to the prior right of the attaching non-enemy creditor. Whether or not the attachment is a lien within the provisions of Section 8A. In one case, however, the custodian was successful in a motion to vacate the attachment. In the only other reported decision that has been found, the effect to be given to a prior attachment was not squarely decided. Both cases were ultimately disposed of, however, by stipulations which in effect constituted recognition by the custodian's office of the validity of the attachment. C. Partnerships. The partnership field shows perhaps more uh, strikingly than elsewhere among enemy business enterprises the variety and flexibility of the present custodian's power, not only investing and supervising enemy business enterprises, their property, and enemy interests therein, but also in defining and determining the enterprises, persons, and interests subject thereto. Conceivably, an enemy partnership doing business and having vestible property or interest in the United States might consist of a partnership where one or more of the partners, number one, regardless of citizenship, resides in enemy or enemy occupied territory, two, regardless of residence, is an enemy citizen or subject, three, regardless of citizenship or residence, is deemed for other reasons to be acting for or on behalf of, controlled by, or a cloak for an enemy country or person within it, and four, regardless of citizenship, residence, agency, cloak, or control, is deemed an enemy national on still other grounds because the national interest so requires. Under the Trading with the Enemy Act, only partnership residents only partnership, resident, or doing business in enemy or enemy occupied territory could be classified as enemy. Partnerships, resident, or doing business in the United States, irrespective of whether all or some of the partners were enemy citizens or subject, were excluded, although individual partners who were enemy citizens or subjects, wherever resident, could be classified as enemy by presidential proclamation, at common law as well as under World War I statute. A partnership, one of whose members was an enemy, was considered automatically dissolved. Eo instanti. Upon declaration of war, the reasons generally given were twofold. One, commercial intercourse with an enemy, trading, became illegal and, in most cases, impossible. Since the partners could not deal with one another, the carrying on of the partnership business was therefore prevented. Two, in communication or commercial relations with the enemy partner were possible, it nevertheless was illegal since presumably benefit would be conferred on the enemy member by carrying on the partnership. The partnership was therefore deemed dissolved as a going concern, as a going concern. However, the necessity for liquidation of the enterprise, payment of liabilities, and distribution of the remaining assets to the non-enemy partners according to their respective interest remained. This doctrine was applied by the courts so as to delete the definition of enemy partnership from the statute. Since the partnership was automatically and instantaneously dissolved upon the outbreak of a war, it would not be an enemy. Only those individual members who otherwise satisfied the requirements of the enemy definition could be so considered. The World War I decision, therefore, give little or no light on which of the categories listed above would be considered an enemy partnership. They do, however, disclose that the custodian there restored to interest or assets vesting depending on whether some or all of the partners were enemies. The partnership of Reese and Co. and Rosie and Co. contained non-enemy partners, and as assets vesting were there held to be improper. On the other hand, all of the partners of Froelich and Kuttner and Philippine partnership were enemies, and the custodian's seizure of the assets was upheld. Asset seizure was similarly sustained in Sonorensen versus Sutherland, where two American partners had a share in the profits but not in the capital under the partnership agreement. The question whether the partnership was an entity also preoccupied the courts to some extent in considering questions of liquidation and suit against the custodian under Section 9A. The executive order includes partnership within the definition of person and business enterprises. The present custodian has found partnerships as well as individual partners to be enemy nationals thereunder, and has vested partnership assets, partners, interests therein, or both. In Stern versus Newton, he vested assets in this country presumptively belonging to the French partnership, which did business and had its office in enemy-occupied Paris. After finding these facts, the custodian determined, in the language of the executive order, that the partnership was an enemy national. He was held entitled to immediate possession of the vested property against the claim of the plaintiff, a French citizen who had resided in this country since prior to the date of vesting, but subsequent to the effective date of the freezing order, that the property was, in fact, beneficially owned by him. The plaintiff was remitted to his administrative remedy against the custodian, where he was ultimately successful. In another case, the custodian vested the interest of all the partners, enemy nationals residing in Hungary, in a partnership doing business in Massachusetts. The vesting order did not, in turn, assume supervision of the enterprise. A year later, the custodian amended his order to vest the assets of the enterprise and formally undertake its supervision. In the case of Pass and Company, however, where the custodian also vested all of the partnership's assets, only one of the two partners was found an enemy national by reason of residence in Germany. The custodian then found the partnership an enemy national on the ground that it was controlled by him, and the other partner an enemy national on the sole ground, and to the extent that, as a partner, she was acting directly or indirectly for the benefit of and on behalf of the partner resident in Germany, unless perhaps the vesting can be justified. On the ground that all of the partnership capital was contributed by the partner residing in Germany, the custodian's actions seem questionable. If the custodian can use his power to make determinations applying the definition of enemy nationality, thus to extend his vesting power, a way has been found around Mayer versus Graven, and little comes of the statutory admonition to regulate property in which there is an enemy national interest, but to vest only the interest. Use of the definition of the two executive orders as the basis for a determination that a partnership is an enemy national wisely disregards the dissolution doctrine of the earlier decision. The World War I rule that a partnership dissolved as a going concern was no longer an entity for purposes of the enemy definition ignored reality as well as the language of the statute, and some further extensions of the agency and control definitions and application has doubtless been necessary and advisable. Indiscriminate discriminations of enemy nationality on control or national interest grounds, however, based solely on residence in enemy-occupied territory or on enemy citizens regardless of residence, or even on residence in enemy territory as a basis of vesting seems unwarranted by the necessity of the situation when other measures are at hand. The broader powers given the custodian in World War II make it unnecessary to go to this other extreme by jeopardizing non-enemy interest which can be subject to supervision and control without the necessity of vesting.